Mr. Attorney General, deciding between the military and civilian forms for trial, that has a lot of consternation in the political community with regard to this question. I know that we have a history with regard to that through several administrations. Once the task force that you just described, once that task force decided which individual would be referred for prosecution, and then there was a subsequent process set up to make the charging decisions for each detainee. This process has been the source of some of the most vigorous Guantanamo-related debate, and as there are a significant number of individuals who are opposed to even the consideration of holding detainee trials in Article III courts or civilian courts, these individuals advocate for holding any of these trials in a military commission. Just past experience in previous administrations, we have held a number of terrorist trials in Article III civilian courts, have we not, through various administrations, Democratic and Republican?
Well, that's true. I mean, your opening remarks were accurate. There are approximately 300 people or so who are in our federal prison system now as a result of their movement through the Article III system. I believe in the last administration there are about 150, 160 trials or so in the Article III courts.
Well, there's some indication in the press we have picked up, and I guess nothing determinative of the question, but it appears that the administration may be considering and maybe openly considering the possibility of moving the 9/11 trials into a military setting. Is that an indication of a change in the administration's overall policy?
No, I wouldn't say so. We remain committed to using all of the tools that we have in trying to win this war. That means trying people in Article III courts, trying people in military commissions. When I announced my decision to try Khalid Sheikh Mohammed in an Article III court on the same day, and actually during the same announcement, I indicated that 5 or 6 detainees were going to be tried in military commissions. And so certain cases are more appropriate in Article III courts, certain ones in military commissions, and one of the things that this administration wants to hold on to is the ability to use our discretion to try these detainees in the appropriate forums.
Well, why should we keep open the option of civilian Article III prosecution for these terrorist suspects?
Well, I think one can look at the history of what we've had in Article III courts. They are tested. We have tried a number of these cases in Article III courts. They are secure. We have tried these cases in a safe manner. We have the ability to guard secret information through the Classified Information Protection Act. Our allies around the world support us in bringing these cases in Article III courts. We have the ability to disrupt and to detain people through the long sentences that we get out of Article III courts. We've also, and I think very significantly, had the opportunity through the Article III court system to get cooperation from people who are charged there and who do not want to face either long sentences or the prospect of serving significant amounts of time in our supermax facilities. We saw it from Zazi, from Headley, from Abdul Muttalib, all people who cut deals so that they would have an ability to share information, intelligence that we wanted, and that they could receive some favorable treatment. And then I think lastly, one of the things that you can clearly do in an Article III court that you cannot so clearly do in a military commission is accept a guilty plea in a capital case.
It seems to me, looking at it as a lawyer, that there are a lot of tools in a civilian court that the court has to manage the not only just the process of the trial, but also the decorum of the defendant, and that seems to be a real concern that defendants in these courts take opportunity to propagandize.
That's actually a very good point, Mr. Chairman, and one I think there is a misperception that somehow or other, if we have a trial in an Article III court, this will become a forum for these defendants to spout their hateful language, their propaganda. And if one compares the way in which these defendants are treated in military commissions as opposed to Article III courts, that is anything but the truth. In the case that I mentioned before involving this woman Siddiqui, she was in an Article III court in New York City, and she was in her trial for 1 day. The judge determined that she was a disruptive influence, that she was trying to disrupt the proceedings, and she was removed from that courtroom and watched her own trial from outside the courtroom. In military commissions, I think what we have seen, certainly with regard to Khalid Sheikh Mohammed, long speeches about a whole variety of nonsensical things, but the judges there, I think, don't feel as comfortable in removing or clamping down on a defendant who's trying to do that.
Who's involved, Mr. Attorney General, in the process of deciding which detainees will be tried in a civilian court and which might be tried in a military commission?
It's ultimately my decision in consultation with the Secretary of Defense. We have a protocol that we have put together and that we use because these are national security determinations. The President is consulted as well. But there is, as I said, a protocol that has been worked on and that the Secretary of Defense and I apply in making determinations. The decision is ultimately mine, but as I said, also involves consultation with the President.
Well, you may have already touched on this, but I'd like for you to elaborate. I think it's important for the committee, it's important for the overall debate. There must be circumstances where it's the preponderance of your consideration or the criteria you use suggests an Article III court, and situations where a military commission would be the best forum. Could you elaborate on that a little bit? What is going through your mind? What is the criteria being used as these decisions are being made and ultimately by you?
Well, on the same day that I announced the decision to try Khalid Sheikh Mohammed in a Article III court in New York and made the determination that a man named Nashiri would be tried in a military commission. He's one of the people responsible for the bombing of the USS Cole. A military target was involved. The casualties were are brave sailors, military men. And that's one of the distinctions that we made. There are rules of evidence that exist in the military commissions that are more favorable towards the acceptance of hearsay evidence. You have to look at these cases individually and on a case-by-case determination make the decision as to where the case can be best tried. And it doesn't mean that you're being unfair, I think, to the defendant. You're simply looking at the forum that really best suits the particular facts of each case. And military commissions certainly play a role. We have, with the modifications, the amendments that were done to the military commissions a couple of years ago, I think those are fine places which these cases...
About the question of national security concerns, does that enter into these decisions?
Although I think not to the degree that some of the critics of my earlier decision have indicated. Concerns about the leaking of information, the protection of national security secrets, sources, and methods can be equally accomplished in Article III courts as they can in military commissions. In fact, the system that is in place in the military commissions to protect secrets is actually based on SEPA, the act which has been in effect for an extended period of time in the Article III system.